Welcome to the Bare Metal Cyber Security Plus podcast. This series helps you prepare for the CompTIA Security Plus exam with focused explanations and practical context. For a companion study guide, check out the Achieve CompTIA Security Plus 701 Exam Success by Dr. Jason Edwards. It is the most concise and complete Security Plus guide on the market, built for busy professionals who want to pass the exam fast and on their first try. You can find this book and others at cyberauthor.me. Cybersecurity is not just a technical discipline, it is a legal and ethical one. As more organizations collect, process, and store personal data, the risks related to privacy and legal noncompliance grow rapidly. Today's organizations must not only protect data, they must handle it according to strict privacy laws and clearly defined legal rules. In this episode, we explore the privacy and legal implications of compliance. We will look at global privacy regulations, such as the General Data Protection Regulation and the California Consumer Privacy Act, and we'll define key roles like data subject, data controller, and data processor. Understanding these legal frameworks and responsibilities is essential not only for exam success, but for real-world operational integrity. Let's begin with privacy laws and regulations. Over the past decade, the rise in data breaches and digital surveillance has led to a wave of legislation aimed at protecting individual privacy. These laws establish rules about how personal information is collected, stored, shared, and deleted. Compliance is required at multiple levels: local, regional, national, and even international, depending on where the business and its users are located. One of the most important and widely discussed privacy laws is the General Data Protection Regulation, or GDPR, which took effect in the European Union in 2018. The General Data Protection Regulation applies to any organization that collects or processes the personal data of European Union residents, regardless of where that organization is based. That means a company in California or Singapore must comply with the General Data Protection Regulation if it handles data from users in France, Germany, or Spain. The General Data Protection Regulation includes strict requirements for transparency, data minimization, consent, and breach notification. It also gives individuals the right to access their data, correct it, and request that it be deleted. The so-called right to be forgotten, violations of the regulation can result in fines of up to 20 million euros, or 4% of global annual revenue, whichever is higher. Let's consider a practical example. A mobile app company based in Canada collects email addresses and behavioral data from users around the world. The company includes several thousand European Union users in its database. Under the General Data Protection Regulation, the company must provide those users with clear privacy notices, a mechanism to withdraw consent, and a process to delete their data upon request. When one user from France requests deletion, the company delays for weeks, failing to meet the 30-day deadline. As a result, the company is fined by a European Data Protection Authority. This case illustrates how even globally distributed companies must comply with international privacy laws if they handle international user data. Now let's look at the California Consumer Privacy Act, or CCPA. This law applies to certain businesses that collect personal data from California residents. It gives individuals the right to know what data is being collected, request deletion of that data, and opt out of its sale. Like the General Data Protection Regulation, the California Consumer Privacy Act applies regardless of where the company is located, as long as it meets the size or revenue thresholds defined by the law. Under the California Consumer Privacy Act, organizations must provide a Do Not Sell My Personal Information link on their websites, maintain privacy notices, and respond to consumer requests within specific timeframes. Fines for violations can reach thousands of dollars per violation, and lawsuits may follow if personal data is breached and the organization failed to implement reasonable safeguards. Imagine a clothing retailer based in New York that sells to customers nationwide, including California residents. The company uses customer data to personalize advertising, but does not include a privacy policy or opt-out mechanism on its website. After receiving complaints, the California Attorney General investigates and finds multiple violations of the California Consumer Privacy Act. The company is fined and required to revise its website, update its data handling practices, and provide customer training. This example shows how regional laws can have national and even global reach. Other countries and regions also have their own laws, such as Brazil's Lei Geral de Proteção de Dados, Canada's Personal Information Protection and Electronic Documents Act, and Singapore's Personal Data Protection Act. Organizations with international operations must be aware of these laws and adapt their privacy programs accordingly. Now let's turn to legal responsibilities in the context of data handling. 3 terms are especially important in understanding compliance requirements: data subject, data controller, and data processor. The data subject is the individual to whom the personal data belongs. This could be a customer, an employee, a student, or anyone whose personal information is collected by the organization. Privacy laws are designed to protect the rights of data subjects, giving them control over how their data is used. The data controller is the organization or entity that determines the purpose and means of processing personal data. In simple terms, the controller decides why the data is collected, what it will be used for, and who will have access. Controllers are responsible for ensuring that data is collected legally, stored securely, and only used for the purposes communicated to the data subject. The data processor is a third party that processes data on behalf of the controller. This includes vendors, cloud service providers, payroll companies, and contractors. Processors do not make decisions about how data is used. They simply act according to the controller's instructions. Even so, they are still responsible for implementing strong security controls and complying with relevant privacy requirements. Let's examine a practical scenario. A university collects student enrollment data and uses a cloud service to host its student portal. In this case, the university is the data controller, the cloud provider is the data processor, the students are the data subjects. If the cloud provider experiences a breach due to misconfiguration, the university is still responsible for notifying regulators and affected individuals because the university controls the data and is accountable for its protection. However, the processor may also face penalties if it failed to follow required security practices. Misunderstanding these roles can lead to serious legal consequences. For example, if a data processor shares personal data with another company without the controller's consent, both parties may be held liable under privacy laws. That is why contracts between controllers and processors often include strict terms about data use, access, retention, and notification in the event of an incident. Here is another real-world case. A social media platform allowed advertisers to access personal data beyond what users had consented to. In this situation, the platform was acting as both controller and processor. Regulators found that the company had failed to protect data subjects' rights, and the company was fined heavily for violations of transparency, consent, and data minimization rules. This case reminds us that roles and responsibilities must be clearly defined and followed to avoid legal and financial fallout. As you prepare for the Security Plus exam, you'll need to understand not just what privacy laws exist, but how they apply in real-world scenarios. Be ready to identify who qualifies as a data subject, controller, or processor in a given situation. Expect questions that describe data transfers, consumer rights, or breach responses, and ask how legal responsibilities are assigned. Here's a study tip. If a question describes someone making decisions about why and how data is collected, that's the data controller. If it describes a third party performing data tasks under instruction, that's the data processor. If the question focuses on individual rights or consent, it's referring to the data subject. Keep these rules straight to avoid confusion and answer with confidence. Thanks for joining us for this episode of the Bare Metal Cybersecurity Plus podcast. For more episodes, tools, and study support, visit us at baremetalcyber.com. And before you take the test, make sure to check out the practice questions in the book Achieve CompTIA Security Plus SY0-701 Exam Success by Dr. Jason Edwards. They cover every domain and are a powerful way to lock in your knowledge.